Good afternoon, good evening, or good morning, wherever you will be watching this match. This is a match counting for the Egg Inter-University Law Debate Tournament. We are in the second day now of the group phase. My name is Aurélien Lorange, and together with my colleague, Miss Munteanu, Miruna Munteanu, we'll have today a match between two teams for this group. We are in the group B of the group phase with on one side, the University of Lagos in Nigeria, and on the other side, the French University in Armenia, Université Francaise en Armenie. And both of them already had one match 2 weeks ago, and now this is the second match for them to qualify for the 8th of finals, which will be after the end of this group phase. So they received a topic 1 week ago, and they will be debating. They don't know yet the position, of course, for this match, so they will discover it in a few minutes. But first, I would like to give the floor to the participants themselves, the students. So I will ask each of them to, of course, introduce themselves. So we'll start at the University of Lagos with Miss Yadesola Shodimu. Could you introduce yourself, please?
Yes, thank you. I'd like to confirm if I am audible enough.
Yes, you are. Yeah.
Thank you. My name is Shodim Jadisola. I am a fourth-year law student of the University of Lagos.
Thank you. Welcome. We have on the side of the French University in Armenia, Université Française en Arménie, Miss Svetlana Merkatian.
Yes, thank you. Good evening, everyone. I'm Svetlana Mukarchan from French University in Armenia. I'm a fourth-year law student, and I'm happy to share this experience with you. Good luck, everyone.
Thank you very much. Now, back in Nigeria, we have as the second member of the team representing the University of Lagos, Mr. Kelechi Praise Alpheus. Could you introduce yourself, please?
Good evening from Lagos, Nigeria. My name is Kelechi Praise Alpheus. I'm a final year student in the University of Lagos.
Thank you. Welcome. On the side of the team within Yerevan, in Armenia, we have as a second member Miss Tatevik Gazarian.
Hi, I'm Tatevik Gazarian from French University in Armenia, a fourth-year law student. I wish everyone good luck and hope we have great time while doing the debate. Thank you.
Thank you very much. Then we have as a third member at the University of Lagos, Adigunju Oluwatomilade Victoria.
Hello, everyone. I would like to confirm that I am audible and visible.
It's difficult a little bit, but if you indeed speak loud and you articulate, then it will be fine. Yeah.
Hello, my name is Oluwatomilade Adigunju. I'm a fourth-year student in the University of Lagos. I am looking forward to this match. Good luck to everyone.
Thank you very much. And the last member on the side of the French University in Armenia, Miss Louisa Melkoumian.
Hello everyone, I'm Louisa Melkoumian, a fourth-year law student from French University in Armenia. I'm very glad to be here, and good luck to all of us. Thank you.
Thank you very much. We have as well the presence of the coach, two coach, so Paranzem Mikaelian.
Thank you very much, and greetings to the members of all teams, organizers, and fellow coaches. Well, this time the topic was very interesting, but a very complex one, which required a lot of research from the part of the students, and it was also a topic close to our hearts, given the current geopolitical situation in which Armenia finds herself. So very much looking forward to the debate, and to all the participants, don't forget to enjoy the process. Thank you.
Thank you very much. And I think we have as well Miss Arpine Arakelian, right?
All right. Hello, everyone. Thank you very much. I'm Arpine. I'm assistant lecturer at French University in Armenia. I wish good luck to all participants and look forward to the process of this debate, which is going to be very interesting for us to follow.
Thank you very much. And we have on the side of the University of Lagos, not present in the room, I think, at this moment, but the team has been coached by Professor Shalom Ajibade, who was as well coached last year in the first participation of the University of Lagos. So greetings as well to Professor Ajibade. So now it is time, of course, to do the allocation of the positions, but first I have to announce, of course, the topic that you were working on during all these days, I mean for 7 days exactly. So you receive as a topic all states, regardless the recognition by the majority of the international community, should have equal access to international judicial bodies to ensure the protection of their people and the principles of justice and fairness. So this topic, you received it by email at the same time last week, on the same days on this week. And now I will share my screen, because we'll do the allocation of the positions between the two teams, in favor or against. So normally you should see as well on your screen both teams. Yes, the wheel with two possibilities for each university, either to be in favor, either to be against. So now we'll know which position you will prepare, you will defend during the match. So for this match, the French University in Armenia will defend the position against. As a consequence, it means that the University of Lagos will defend the position in favor. And at the same time will start the match, because it's always a position in favor who starts the match. So concretely, I will translate it in this way. The University of Lagos will defend the position that all states, regardless of recognition by the majority of international community, should have equal access to international judicial bodies to ensure the protection of their people and the principles of justice and fairness. While the French University in Armenia, Université Francaise en Armenie, will defend the position that all states, regardless of recognition by the majority of the international community, should not have equal access to international judicial bodies to ensure the protection of their people and the principles of justice and fairness. So now you will see the 5 minutes, but I don't know if my colleague, Miss Montano, you have the 5 minutes countdown, or shall I do it?
I do not have the website as my laptop is a bit crashing, so I won't share my screen, but I do have my timekeeping here.
I will share my screen then. Okay, it will come up, voila. So I remove the commercials. So you have 5 minutes. It means that you can close your camera and audio to prepare, and in 5 minutes we start the match. So, you can open your camera. We'll start in a few seconds. I stop sharing my screen. So now we are back in the room. Doing the randomizing of the positions. That was University of Lagos who will be actually starting, so it means who is in favor. So I would like to give the floor to the University of Lagos for the introduction. You have 4 minutes.
Thank you very much. Before my time start running, I would like to confirm if I am visible and audible enough.
Yes, both.
Thank you. In the words of Martin Luther King Jr., true peace is not merely the absence of tension, it is the presence of justice. If we want justice, states must have equal access to international judicial bodies. Good day, honorable judges and my co-debaters. My name is Shodi Ujadesola, and alongside my colleagues Kelechi Alfios and Oluwatomilade Adebunju, would be supporting the motion that all states, regardless of recognition by majority of the international community, should have equal access to international judicial bodies to ensure the protection of their people and the principles of justice and fairness. I'll be making my argument with 3 salient points. 1. The concept of recognition is too subjective to be a determinant to access justice. 2. Lack of equal access to international judicial bodies will hinder the objective of international judicial bodies. And thirdly, equal access of all states to international judicial bodies upholds the integrity of these bodies. Now to my first argument. The element of recognition is one that is riddled with subjectiveness. As states individually decide whether or not to grant another state recognition based on their own national interest. A typical example is that of the United States and Palestine. Although 138 members of the United Nations recognizes Palestine as a state and chose to make Palestine a member state of the United Nations. However, the United States vetoed a resolution, and as such, Palestine could not become a member state of the United Nations. Also, the concept of recognition is more like a privilege that can be given and taken away at any time. Another classical example is that of Abkhazia and Ossetia. Initially, 7 members of the United Nations had initially granted this state recognition until 2014 when Tuvalu suddenly withdrew its recognition. Regardless of all this, however, the position of the law is very clear. Article 3 of the Montevideo Convention on the Rights and Duties of a State provides that the political existence of a state is independent of recognition by other states, and consequently, all states should have the right to have equal access to justice. And now to my second point. International judicial bodies are performing their fundamental objectives by giving access to states. These bodies exist for the primary purpose of amicable settlement of disputes between states and promotion of the principles of justice. Which is why, for example, Article 34 of the ICJ, only states can be parties to matter inter-court. Now to our final argument, which is that allowing equal access of all states to judicial body upholds the integrity of international judicial bodies in the protection of the principles of fairness and justice. Delivery of justice should be impartial and non-discriminatory. In the declaration of the high-level meeting on the rule of law, member states highlighted the impartiality of international judicial bodies as an essential prerequisite to upholding the rule of law and ensuring that there is no discrimination in the administration of justice. Where there is no integrity of the judicial bodies, there will be impunity in the judicial scene. If, hypothetically speaking, Ukraine is not given access to the ICJ because Russia and majority of the international community does not recognize it, it shows that such international judicial body is being partial and chosen with one state, and as such, a state like Ukraine would be unable to get justice for their redress. Before I close the floor of this debate, I would like to leave you with the instructive words of Judge. Thank you.
Thank you. Thank you very much. Now, I would like to give the floor as well for the introduction to the French University in Armenia, Université Française en Arménie. Vous avez 4 minutes, sorry.
Thank you very much. Ladies and gentlemen, we have come together today to address an issue that requires international legal consideration. Our team firmly holds the position that the statement claiming equal access to international judicial bodies for all states, regardless of their recognition status, does not align with the current legal framework for the following reasons. First, international judicial bodies derive their authority from international law, which is based on the recognition of states as legal entities. Without legal recognition, states cannot fully participate in the international legal system or claim the same rights and privileges as recognized states, as they are not considered to be equal sovereign entities under international law. This is stated in Article 2.1 of the UN Charter, which states that the organization is based on the principle of the sovereign equality of all the members. Notably, the term members refers only to recognized states, as non-recognized states cannot be members of the UN. This is further supported by Article 36 of the ICJ Statute, which specifies that the jurisdiction of the court is based on the consent of the parties, and only states can be parties to cases before the court. However, this does not mean that non-recognized states have equal access to the court, as they must first have their statute recognized by the international community in order to be considered a state under international law and be able to bring a case before the ICJ. This position has been upheld in ICJ cases such as Kosovo versus Serbia, Palestine versus Israel, etc. Second, the international legal system is based on the recognized sovereign states holding rights and obligations under international law. Allowing access to international judicial bodies for non-recognized states would create discrimination, potentially leading to chaos and negative precedent setting, complicating the operation of international judicial bodies and creating difficulties in upholding the rule of law. Third, recognition of a state is often influenced by the interests and political strategies of recognized states. If they do not consider it necessary to recognize a state, there are likely to be reasons for this decision, such as state's legitimacy, territorial claims, or human rights record. For instance, non-recognized states that do not conform to the common European understanding of human rights may have difficulty joining the European Convention of Human Rights and accessing the European Court of Human Rights. Finally, non-recognized states' participation in international legal proceedings presents a challenge for enforcement, as international legal bodies lack sufficient framework and influence to ensure compliance. In addition, non-recognized states may not have the same level of resources or infrastructure to comply with the decisions. This could lead to a lack of credibility and effectiveness of the international legal system. In summary, states which are not recognized by the majority of the international community cannot be granted access to international judicial bodies on an equal basis with recognized states. Allowing such access would not only undermine the principle of sovereign equality, but also pose a serious threat to the effectiveness of these bodies. It is therefore vital to ensure that international law is upheld and that recognized states are granted the privileges they deserve. Thank you.
Thank you very much. So now we start the rebuttals. We start with the first rebuttal. That is the University of Lagos. We'll do it. So you have 2 minutes.
Thank you very much, and good evening once again from Lagos, Nigeria. My name is Kelechi Alpheus, and I will be taking the first argument for the proposition side. We thank the opposition for their very solid argument. However, we fear that they may have misconstrued the topic, as we are not here to argue the position of what is, but the position of what should be, in the light of what would amount to justice and fairness. We are not arguing on the position on what international judicial bodies hold as regards to whether recognized states should be, whether unrecognized states should have access. But we are saying rather that irrespective of majority of international community recognizing certain states, they should still have access, irrespective of what the position is. Um, as such, I'll be making few rebuttals, nevertheless, on some of the points the opposition have mentioned. The opposition have mentioned that there will be difficulty in upholding the rule of law. We beg to differ on this stance. We strongly believe that the position of the law right now is one that would cause that one that should be upheld.
Well, Mr. Alpheus? Mr. Alpheus? I'm waiting for Mr. Alpheus to... So, Mr. Alpheus, and as well to the team of Lagos, we'll pause actually the chronometer like 27 seconds before the end. It was 28? I don't know.
Yeah, 30 seconds. He still has 30 seconds.
Still has 30 seconds. Okay. So, so what I would advise indeed to everybody except Miss Munteanu, to just make sure that... Yes, Mr. Alpheus, can you hear me?
Yes, right now I can hear you.
Yes. Mr. Alpheus? Not yet fully stable, I think. So what I was going to tell is that we'll give indeed the last 28 or 30 seconds to make sure he can finish, and we can hear, of course, properly the end of the 30 seconds because it's a technical problem at this moment. So, so it's totally independent from the will of the student. And I don't know. I will type. I will ask him to reconnect instead of trying to.
Am I audible or visible right now?
You are audible, but not yet visible. And can you manage maybe to reconnect? I think if all of us, except Mr. Alpheus and as well Miss Munteanu, because we need to see the chronometer, if all of us we switch off our camera for a few seconds for the end of his speech, we will manage to, I guess, help for the internet, for Mr. Alpheus to be able to finish. Hop. So Mr. Kelechi Alpheus, can you hear us? So yes, Mr. Alpheus is reconnecting. No, he left. No, now he's reconnecting, I think. So when you can hear us, Mr. Alpheus, you can let us know. Yes, he's reconnecting from a different device. Mr. Alpheus.
Am I audible right now?
I think you are audible, yes. And can you hear me well?
I can hear you perfectly.
Okay.
Am I visible?
Now you are visible as well. So now...
I strongly...
So what we'll do is I will give you 30 seconds because it stopped at around 30 seconds. So if... Yes? Can you hear me?
Okay. Yes, I can.
Okay.
May I proceed now?
So you can proceed, you still have 30 seconds. We stopped before there was a problem.
Thank you very much. So just before the network cut off, I was discussing the issues raised by the opposition on rule of law and challenges of enforcement, as well as lack of infrastructure. It is our belief that all of these do not pose any serious or regrettable effect on states that are recognized as opposed to states that are unrecognized, and the opposition have failed to show us how this would affect equal access to international judicial bodies. The crux of this matter is how can we give access to certain states that are not recognized for the sake of justice, and particularly for the people of the state. We want to firmly hold that.
Right. Yes. Ms. Montano, yes, we saw it.
National human rights is very important and should be upheld.
Mr. Alpheus? Bon.
And as such, access to judicial bodies of recognized and non-recognized states should be at par.
Okay.
Thank you very much.
So Mr. Alpheus? I think yes. So, Mr. Alpheus, just for you to know...
Was I cut off again?
Yes. So what I would advise, and if everybody is okay, is that we'll ask you to do your part, but this time without camera, because with the camera it seems that it is impossible. And of course we'll do our best on our side to switch off the camera, but what is important is that we can hear you more than we can see you, because we know that of course you are speaking in front of your device. So are you okay that you can restart your part 2 minutes, but without camera, okay?
Okay, I have also tried to change my network, so I believe it should be more stable now. I apologize for the technical issues.
No, it's fine now. At this moment it's very good, but without the camera is fine. So please, you can restart so we can hear you well. Okay, you can proceed.
Thank you very much. Apologies for the technical issues once again. The opposition have done very well in their presentation. However, we would like to state that it may seem as though they have misinterpreted the topic, as the topic for this debate today is not one that requires us to debate on the stance of things or the state of things as they are, but requires us to open our minds into the reality and what would constitute a more justiciable system, or a system that helps with shedding more justice in the international community. They have raised issues of difficulty in upholding the rule of law, as well as the challenge of enforcement if unrecognized states are given the opportunity to have access to international judicial bodies. However, we stand firmly on our point that these issues they have raised do not particularly create a situation where unrecognized bodies should not have access, especially in light of the principles of fairness. This is simply because issues of enforcement have more to do with willingness of states to conform with the law, as opposed to whether they are recognized or unrecognized. We stand firmly on our point that recognition should not be a prerequisite, as it is a mere political fixture, political nomenclature, as opposed to a technicality that would help in the attainment of justice. They have also said that unrecognized states lack infrastructure to hold or to uphold the results of international judicial bodies. And our position on this is that this is not particularly true. Like, as I have already said earlier, conformity with the decisions of international judicial bodies have more to do with willingness of the states as opposed to whether a state is recognized or unrecognized. I would like to remind this tribunal that the crux of today's debate is, should recognition be a bar on states? Should recognition create a bar on states in accessing international judicial bodies for the purpose of justice? Justice. Thank you very much.
Thank you very much. So now, as well, for the first rebuttal, I would like to give the floor to the French University of Armenia. You have 2 minutes.
Thank you. So, after examining the opposing team's position, we find it insufficient to stand against our argument for these main reasons. First, unlike non-recognized states, recognized states are bound by international law and conventions, and their compliance with the decisions are more likely to be enforced. And yes, we agree that the enforcement is a practical difficulty, but when the recognized states, even the recognized states, fail to enforce the international judicial bodies' decisions, it is more likely to be problematic for the non-recognized states. Moreover, non-recognized states are considered unstable, and there is always a risk of dissolution or some unexpected changes that the state cannot predict or prevent. International judicial bodies rely on the recognition of state authority to carry out their functions. In non-recognized states, there may be competing claims of authority and control over territory, which can complicate the application of international law and the ability of international judicial bodies to make binding decisions. Additionally, Article 38 of the ICJ Statute emphasizes that the rule relied upon by the parties in a case must be explicitly recognized by them. However, a non-recognized state may have difficulty accessing to international conventions, let alone claiming their application before the ICJ and other international judicial bodies. This position has been upheld in ICJ cases above mentioned, as I have already mentioned, Kosovo versus Serbia, Palestine versus Israel, etc. So we are remaining on our primary position. Thank you.
Thank you very much. So now for the second rebuttal, the University of Lagos. You have 2 minutes.
Once again, we thank the opposition for their position. However, we must state clearly that when it comes to compliance with judicial decisions at the international level, it is not a thing, an issue of recognition or unrecognition does not come up. It is simply based on the willingness of states to uphold these decisions and not an issue of recognition or unrecognition. Also, we stand firmly on the point that the entire essence of international judicial bodies is to uphold justice and to amicably resolve disputes irrespective of where they are coming from. As such, there should be no discrimination on basis of race, on basis of nation. It should be solely based on the requirements of statehood and as opposed to the requirements of recognition. As such, we believe that justice for a few on the basis of recognition or lack thereof is not a good determinant of who should have access to the international judicial bodies. And we stand firmly on our point. Thank you very much.
Thank you very much. Second rebuttal as well now for the French University of Armenia. In Armenia, you have 2 minutes.
Okay, thank you very much. I respectfully reject the opposing team's position as it fails to acknowledge the crucial factors that are central to the topic of the debate. The opposing team didn't take into consideration the fact that allowing non-recognized states to participate in international judicial bodies could also create a potential for abuse, as non-recognized states may use their participation as means of advancing political objectives or manipulating the legal system for their own benefit, rather than seeking legal remedies. This could undermine the integrity and impartiality of international judicial bodies and have negative consequences for the rule of law. That's it. Thank you very much.
Thank you very much. Now it is time for the conclusions. So we start with the conclusion by the University of Lagos. You have 2 minutes.
Before my time starts running, I would like to confirm if I am audible and visible.
So, yes, you are visible and audible as well.
Thank you very much. In 1963, during the height of segregation, Martin Luther King Jr. said, "Injustice anywhere is a threat to justice everywhere." My name is Oluwatomilade Adedi, and in 2 minutes, I'll be summarizing and buttressing the arguments on behalf of equal access to justice by states unrecognized by majority of the international community. My teammates have stated salient points, including the ambiguity of the requirement of recognition, as well as the importance of the equal access to international judicial bodies. And a major contention of our opposition has been the politicization and abuse of these judicial bodies. But we are submitting that even in cases of human rights violations, access has been denied to these states. For instance, in 2009, the Minister of Justice of Palestine, an unrecognized state, conceded to the jurisdiction of the ICC, International Criminal Court, following the Gaza Strip war that included armed hostilities and human rights violations in various degrees. Not less than 300 children lost their lives in this war, but yet the ICC was unable to carry out investigations immediately, as there was controversy over whether or not Palestine was a state for the purposes of ICC's jurisdiction. And as we all know, justice delayed is justice denied. In conclusion, we would like to say that if the fundamental purpose of an international judicial body is to ensure equal justice or even justice, why should a set of people be excluded based on ambiguity, semantics, and the biases of other countries? Thank you very much for listening attentively.
Thank you very much. Now we will listen to the conclusion by the French University in Armenia as well. You have 2 minutes.
Yes, can you hear me?
Yes.
Okay, I'll start. In my opinion, my opponents have failed to consider the full scope of the issue at hand. Firstly, I would like to draw your attention to the case that was mentioned numerous times during this debate, Israel versus Palestine, which was briefly discussed by my teammates also. In 2004, the International Court of Justice issued an advisory opinion on the construction of a wall by Israel at West Bank, and Palestine argued that the wall was a violation of international law and asked ICJ to issue an opinion on the matter. However, the court also declined to hear the case, stating that Palestine was not a state under international law. Secondly, the opposite team fails to acknowledge that under the constitutive theory of state recognition under international law, the state does not exist till it's recognized by others. Therefore, non-recognition excludes sovereignty, thus also equal access to international judicial bodies. Moreover, non-recognized states also lack the other obligatory elements required to be recognized as a state, such as, for example, the control over their territory, which can create competing claims of sovereignty and complicate their participation in international judicial proceedings. In conclusion, the international judicial system restricts equal access of non-recognized states to international judicial bodies for a reason: to maintain world peace and reduce political tension between countries, especially at times like this, when every little spark can cause a big fire. That was it. Thank you for your attention.
Thank you very much. So we are done with this match and concretely with the debate. So it means from now you are not under evaluation, and as well I want to add for the judge to ignore the technical issues that the teams had or may have. So only the content, of course, of what has been said and debate actually enter into the consideration for the assessment of both teams. So now we move to the quick feedback, because actually, we will have only a few minutes. So I will give the floor to each student to know how they prepared and how actually they thought about the match. So Miss Yadesola Shodimu, what did you think about the match?
Am I audible and visible?
Yes, you are.
Thank you. So preparing for the match took a lot of research, and I really learned a lot of things from the topic, things I didn't know from international law. And I'm really glad I got to hear so many different perspectives and a different angle from this topic I had never thought of. It was really amazing meeting a lot of people and preparing with other people. Yeah, thank you.
Thank you very much. Miss Svetlana Merketian.
Yes, thank you. So the match was awesome, and we think, me personally, I think that all the teams, regardless the results, we all learned a lot. We all gained lots of new knowledge about the international law, about recognized and non-recognized states, etc. And it is really important in this era to know and to develop such issues. So thank you for organizing. Thank you for the subject of the debate and topic of the debate, and also thank you everyone, all the teams. It was awesome.
Thank you very much. Mr. Kelechi Praise Alpheus.
Am I audible?
Yes, you are audible.
Okay, I apologize for my technical issue once again. And I thank everybody for their patience, irrespective of the technical issue. We did try our best, do due diligence before the match, had several practices with our videos to make sure something like this does not occur. However, there are circumstances beyond our control. Irrespective, it was an amazing match. We did a lot of practice, a lot of research into the topic. We had to delve into historical backgrounds of international judicial systems and figure out their objectives, and also do a lot of research on the issue of recognition. And I think it was an amazing match irrespective. So thank you to everybody.
Thank you very much. Now I give the floor to the second member of the team from the French University in Armenia, Ms. Tatevik Gazarian.
So the debate was once again quite interesting, and I think it's fair to say that it was particularly interesting for us, as the topic was related to nowadays problems in Artsakh and all the war, etc. And for us, it was quite interesting to learn new things, to realize how actually these international judicial bodies work, and what we can, that there are two opposite sides of the same coin, and we need to learn more to understand how can we finally achieve world peace and ensure the equality between all states, which was again an amazing work, and I enjoyed the debate. So hopefully there will be more. Thank you.
Thank you very much. In Lagos, Miss Adegunju Oluwatomilade Victoria.
Am I audible?
Yes, you are audible.
So as someone interested in MUN, it was amazing for me to see another perspective to how United Nations works, the ICJ works, and during the process of the research, having to research both sides and to see how both sides have valid arguments and like hearing the arguments and listening to opposing teams' arguments was very amazing for me. And I am very, very thankful for this opportunity to be able to speak and debate with the opposing team. And I wish us best of luck. Thank you.
Thank you very much. And the last member as well, on the side of the French University in Armenia, Miss Louisa Melkumian.
Okay, it was very interesting for all of us, I guess. I really enjoyed the process and looking forward for the next one. Thank you very much.
Thank you very much. And I think we have still one coach in the room, I think. So, Miss Professor Mikaelian, what did you think about...
I'm not a professor.
But one day.
Yeah.
Soon.
Thank you very much.
Yeah.
Congratulations on the successful match to all the teams. In terms of preparation, we were more confident this time, knowing how the procedural rules work in practice. And on the substantive issues, like the girls already stated, like it was really interesting to dig deeper into the matter. And as coaches, we also learned a lot along with the team members. And my fellow coach, my colleague Armenie, sent her greetings as well. Unfortunately, she had to disconnect a bit early. And I wish you the best to all the teams for the further matches. Thank you very much.
Thank you very much. So this is the end of this match. As I mentioned, the three judges who will be watching the match will be assessing during the next days. You will receive the result, of course. In 2 weeks, you will have the third and last match of the group phase already. So it means it will be against a team you did not meet yet in the group. And concretely, you will receive the topic next week for that third match. And then, of course, we are looking forward to see you for that last and third match of the group phase. And after that, it will be the announcement of the result of the group phase, obviously, for the 8th of final. So I would like to thank everybody in Nigeria, in Armenia, and as well Miss Munteanu for this match. And we keep in touch, of course, for the next weeks. Yes?
Thank you very much.
Thank you.
Thank you. Bye.
Thank you. Bye-bye. Bye-bye.
Thank you.